Similar arguments were mobilized against the ERA, which was understood to be a government grab at the private life of the family. Ironically, of course, in the face of Moynihan and the welfare debates, this is also the moment at which the private life of families on welfare are being dramatically managed by the state. Conservatives are making two very different kinds of privacy arguments depending upon which kinds of families they're talking about. But privacy can work in all kinds of ways for conservative opponents as well. Take the 1976 Hyde Amendment, which the Congress passed to exclude abortion from procedures covered by Medicaid. Those who want to pay for the abortions of others, Representative Eldon Rudd of Arizona said, can do so by donating to charity hospitals, that is, private hospitals, without robbing taxpayers who prefer not to pay for them. A year later, the Supreme Court ruled in Beal v. Doe in 1977 that states could exclude abortion from Medicaid coverage. The court's ruling struck at the heart of the privacy dilemma. Ruling that federal funding was not necessary to ensure a woman's liberty to control her reproductive life, the court refused to imagine that equal protection might compel the state to extend access to reproductive options to those unable to afford them. In other words, it's fine to see liberty, privacy as liberty as part of a civil right, but you can't see equal access as a fundamental social right or part of a broader social citizenship. In this sense, privacy offered very little protection, and it in fact had become the argument against the public funding of abortion and child care. Okay, I'm moving toward the conclusion. So why does any of this matter? If we step back from the period between the middle 1960s and the middle 1970s, two things easily come to mind. First, that privacy as a demand of social movements in this era varied with the degree of access one already had to both private and public worlds. Those who already enjoyed substantial access to private and public worlds, and here I mostly mean white women and white gay men, or middle-class white women and middle-class white gay men, were the most likely to find privacy arguments compelling. Privacy could be a route to a certain kind of equality if one already possessed the resources to enjoy that privacy. In this sense, privacy looks a lot like free market liberty. Second, and related, privacy as understood by the courts rhetorically inverted the feminist analysis of the period. The courts gradually deregulated the private sphere, at least, again, of families who weren't already on welfare. Gradually deregulated the private sphere and assumed that they could do so because this was already a space of liberty. But women's liberationists had claimed precisely the opposite, that the private sphere was not a space of liberty at all, but one of coercion, constraint, and all too often violence. And the welfare rights movement made the argument that, of course, the private sphere was not private at all. If you have to receive welfare benefits, then you're subject to all kinds of surveillance. In the end, liberal feminists, feminists of color, women's liberationists, liberal gay and lesbian activists, and gay liberationists had to make a case, not that intimate association and sex were private, but precisely which aspects of intimate association and sex ought to be private as a route to equal citizenship. This was a much more complicated argument, and one that was a little bit easier for conservatives to defeat. I also think it's key to understanding the still incomplete transformations in citizenship of the 1960s and 1970s. Too often dismissed as identity politics or identity movements, the social movements discussed here represented a collective, albeit often uncoordinated, assault on the legal and social regulation of the family as it had come to be understood by the middle of the 20th century. Making certain aspects of intimate association and sex private as a matter of liberty was crucial to that project. But so was making certain aspects of intimate association and sex public as a matter of justice. The latter objective has been far less realized, was much more problematic and harder to achieve, a not unsurprising development in a nation that places more value on liberty and equality. But if privacy was a relatively weak legal argument, because it could always be trumped by compelling state interests in the language of the court, and it was never the central argument of the social movements themselves, which preferred equality, why did privacy become so important? For two reasons that have to do with how society and law interact, I think. First, and perhaps most obviously, privacy was the zone of personal liberty recognized by the court. And I think it its recognition of privacy is actually ought to be seen as a conservative or very, very cautious move in this era, not a radical, sexual revolution-making kind of action, but a relatively cautious and one might even say conservative one, as it rejects the equal protection claims of welfare recipients and others. But a second reason is also crucial, I think, and this goes back to the social movements themselves. Privacy arguments enabled those whose bodies and sex had been defined as not respectable to claim the respectability once conferred on the patriarchal family by law and practice. This included, but was certainly not limited to, unmarried women, lesbians, gay men, poor women of color, transsexuals, all of those whose intimate lives in both law and practice had been regarded as not respectable. Privacy was not simply a route to equality then for them, but a route to respectability. A claim that their sex, their bodies, resided not simply in a space of liberty, but in a realm of moral virtuousness and decency. This latter aspect, the respectability of heretofore unrespectable bodies, was precisely the aspect of those social movement claims most resisted by conservative activists, especially with regard to gay and lesbians and with regard to welfare families as well. And I'm finishing here. All of this draws us back into the fractal nature of the public-private relationship, in which new publics and privates unfold the more layers we pull away. Reconstituting a meaningful legal and social basis for family in national life as it sort of explodes in the 60s and 70s has required both the creation and destruction of privacy, and it continues to do so. And this process has involved the complicated interaction between three things. Privacy understood colloquially, often in these social movement contexts. Second, privacy as a privacy or private as a neoliberal or conservative argument against the state. And three, privacy as understood constitutionally by the courts. And I think the upshot of this is that privacy in civil citizenship has not always led to equality in social citizenship, and there's been a real disjuncture between those two. Thank you.